Bill Bishop of Market Watch says, a will might seem like a hassle, but that is nothing compared with the hassles your heirs will experience if you die without one. It is against this backdrop that I welcome you to yet another exciting time out on Let's Talk. I am Olujoke Mosaku, and the topic for today is writing a will. Barrister Gani Ogunsowo Esquire, attorney and principal partner, Gani Ogunsowo & Co. Golf Chambers, is my guest. Stay with us. Welcome, sir. Thank you so much for joining me to actually talk about will.
Thank you, Mosaku. It's a privilege to be on your program today, and I must commend you for choosing this very sensitive aspect of our law. It's a welcome idea.
So what is a will and why is it necessary to write a will?
Well, definition of a will I was in a layman language or in the legal parlance is an expression of a desire by the testator. Don't mind me, testator is just a legal term that means a person that writes will. So it's an expression of desire by testator, showing how he wants his property to be distributed among his children or loved ones, family and loved ones, in a nutshell.
Okay, so is writing a will gender-based?
Not at all. It's not gender-based. A man can write will the same way woman can write will by the Women Property Act. A woman under the law, they are distinct and separate human beings. They can bequeath their property to their children, to their loved one, just the way their husband can also bequeath property to the loved ones.
Okay, in other words, you're saying that it is not also for the haves and the have-nots. I mean the rich and the poor.
That is one of the wrong impression going around, that when you mention professionally, when we advise that will is important at every stage in our life, most people tend to believe that will is meant for the wealthy, the influence in the society. No, will is just an expression of your desire. If you permit me to derail a bit by going into the history, will was the first lawmaker that make submission at the floor of the lawmakers that will people be allowed to dispose their property according to their intention. Was the great Greek man Solon, a statesman, a Greek, and a lawmaker and a poet, who, from his experience, that when most people died in the community without a child, their property goes back to the family, including those who actually appear to be their enemy during their life. Therefore, he made a strong submission that people should be allowed to dispose of their property when they are alive according to their will, to their loved ones. So that was about 630 before the birth of Christ. And since then, Solon was regarded as a very great philosopher from Greek. And from there, the whole world over had adopted it. It had its checkered history in Nigeria. It came into Nigeria through the Statute of General Application that was 1840. And then today, virtually all the states in Nigeria had adopted will law. So it's a global law. It is recognized all over the world. Will as a very strong step in a man's life is acceptable all over the world. It's not limited to the rich, because whether we like it or not, all of us, we have something that we cherish. Well, it is not limited. In essence, let me put it in this way. What are those things that can be distributed through will? You can distribute even your clothes through will. You can distribute your land, your real property through will. You can distribute your limited finance in the bank account through will. You can distribute anything that belongs to you, your personal property. So I want to believe everybody has clothes, everybody has jewelry, everybody has something he cherished. So that thing that you cherish that belongs to you personally, I am very sure you want to give it out to somebody you love. Who is that person? You can only do that through will.
So, at what age or point should one consider writing a will?
Well, by the will's heart, the age is 21 years. From 21 years, everybody is free to write their will. But from Lagos State law, which law is 18 years. Once you attain 18 years and you have property already in your name, because don't forget that will takes over inheritance. It is possible that a child of 18 years inherits some properties from his grandfathers. Such child deserves to have a will. But people, when you mention will, the first thing that comes to their mind is that you are anticipating death. Will is not synonymous with death.
It's true, actually. That's what we think of when someone is about to die, and it's basically the old people that try to write a will when they're about to die.
That notion is wrong. It's not correct. Will is does not speak until after the person dies, and it does not actually reduce the age of the person, and it does not invite the person to death. It's just an expression of your desire, how you want your things to be shared. So once you attain that age of 18 years in some states and 21 years in some states, you are qualified under the law to write will.
So, are there things to consider while creating a will?
Yes, certainly, yes. In a quick one, I will quickly run through 10 important steps that will make a valid will, because we have valid will, we have invalid will. Now, in law, things to be considered when your own decisions to have a will, very important. You must make that decision that I want to have a will. Number two, you must make a decisions that who are the beneficiaries of my will. Number three, you must also make a quick decisions that am I qualified, am I competent to write will on my own, or I need the service of an attorney? Because the truth is, there's no compelling law that says a will must be written by a legal practitioner.
I was actually going to ask you that too.
Okay, so you must make a decision. Am I competent enough to write my own will? Then if yes, go ahead and prepare your will on time. Now ensure that whatever you write is witnessed by at least two persons who are also adults. And then number five, you must ensure that what you are bequeathing to the beneficiaries in your will is real. You can't bequeath a property that does not exist to your beneficiary. It will fail. So it must be real. Then you must identify who are the real executors. You must identify who are the real executors. And not only that, you must, number seven, ensure that you appoint guardian for your kids. In the event the kids are still very young and cannot stand on their own. So you must make sure that you appoint a guardian. And not only that, you must make sure that the will is regularly reviewed and updated. You must make sure that if you have, because uh, like what happened in Nigeria, a case that was decided in Nigeria in 2014, it was a case of Okuluwamu and Okuluwamu. What happened in that case was that the testator was a very rich man, and who eventually traveled to United States of America for furtherance of his business acumen. And then there in USA, he made a will in 1973. And then in that will, he actually said his first son, the man came from Benin, a part in Nigeria, that's the Edo State. So he bequeathed his two houses in Benin to his first son, the first son of the family. And then in 1973, that was when he made the will. The man died in 1979. Meanwhile, before the man died, the first son had already died before him. So the man was alive when his first son died. But the man forgot an aspect of the law, that will must be regularly reviewed and updated. So he didn't update the fact that the first son had died. Therefore, the will passes to the second son, who is automatically the first son by arrangement and by birth. So the man forgot that aspect. So after his demise in 1979, the people continued to live. The first thing that happened was his son, the second son, who is now the first son, took the executors to court, challenging the will, that the will should be declared null and void by the court. And they believe me sincerely, the high courts, set aside that will, because the first beneficiary is late, and the man died even after the first beneficiary actually, died. So they went to appeal. The Court of Appeal confirmed the decisions of the High Court that if a person dies, if a beneficiary dies under a will, automatically that property passes to the next person under the Benin custom. The next person is the second son, who automatically becomes the first son. So in law, he is entitled to that property. So the will must be regularly reviewed and updated. For instance, there are pivotal movements, like when a man has a new marriage, probably the first wife is late, you have a new marriage with another woman, the another woman is having children for you. You need to update your former will to put the interest, to consider the interest of the children from the new wife. And not only that, it is possible that you acquire a new property after you have written your former will. It is important you update your will to put in those new properties, and so on and so forth. There can be new births, you can have new children, and all that and all that. So will must be updated. And lastly, if there are informations that you want to reflect in your will that are also important, you have written the will already, law allows the testator to write a formal letter that bears his signature, with reference to the former will, and put all those informations in the letter and attach it to the will. So all these 10 steps are very important in making a valid will.
Okay, so what are the legal penalties for anyone who decides to go against the rulings of the will? If I may use rulings for the will, I know rulings is for the court.
Like I said, the penalty is in will is a civil aspect. It's not a criminal aspect. But where criminal aspect comes in is where there is an evidence that signature of the testator is actually forged, and the testator and the children and other people are attesting to the fact that this is not the signature of the testator. Now, that aspect can be investigated by the police, and forensic analysis can follow. But believe me sincerely, will affairs in law is purely civil. And what are the likely things? For instance, where the testator is terribly sick during the time the will is alleged to have been made. In that circumstances, the law says that the testator, the purported testator, does not have the sound mind. The law presumes that the testator does not have the sound mind to make such a will. Okay, so it is important that the person must have the legal capacity.
Okay.
Now, what do I mean? For instance, I said it earlier on this program today that by virtue of Section 3 of the state laws, like Benin Wills Law that I mentioned earlier, and Section 2 of Lagos Wills Law, a person under the age of 18 cannot make a will. So if a will is coming on the age of a person who is less than 18 years, the will be set aside in the court of law. And not only that, a witness that will witness such a will must not be less than 18 years. So if all these anomalies are found in any will be set aside. And naturally, in law, when an action is filed successfully, litigated upon successfully, damages will be awarded against the defaulting party. So the party that propounds the fake or defective will be penalized by way of damages. So in a nutshell, that is the penalty in civil art from the civil aspect of in any matter relating to will. So damages is likely to be awarded because the onus is on the propounder of a will to show that the will is valid and sound in law. So, like those two vitiating factors I mentioned, you must be of sound mind and you must possess legal capacity to write a will. The parties, including the witness, must possess the legal capacity to write a will. Otherwise, the will be declared null and void.
So what's the place of government in all this will issue?
Why we always advise people to write will is that whatever effort you put in between your formative years and then the most important year, your useful years of hard working till old age, it will only be showcased to your children if you have a will that passes the property, all your efforts, to your children easily. Will allows people to pass their properties to their children easily without any problem. But when you fail to write a will, or when the person dies, all your property goes back to government. Can you see that?
Mhm.
A woman being is working for less at least 40 years, and all his efforts will not be allowed to be taken by his children. You know why? When a person dies and controversy arises, argument arises, then the government will take over the property.
Wow.
It is a law. That is why we have the office of administrator general in every state, the AG and PT. So the office of the AG and PT will just come forward to take over any property which is subject of argument in any state. So if you don't want government to take over your property, it is advisable you have a valid will passing all your estates to your beneficiaries, to your children, to your loved ones, to the family ones who are actually dependent on you, on the person before he demises.
Thank you so much, Lawyer Ogunsanwo. Well, I know you mentioned it earlier, but I would also want you to give a brief on it. Also, as a legal practitioner, what are the legal proceedings for writing a will? Are there, as a lawyer, you talked about the age, and or are there special legal something to be able to write this will thing?
Like I said, there's no formal law requiring that it will must at all costs be
Okay.
written by a lawyer. If the person is educated, you can write a will. All you need to do is probably to adopt a software on the internet as a guide. The procedure is everywhere on the internet. Like I mentioned earlier, once you form a decision to have a will, that's the first thing, and these are the procedures. You must identify the beneficiaries. Okay, the meaning of this is who are the people that you actually desire to benefit from your estate. Are they limited to your children alone and your wife? And then not only that, in a will, your wife can be your executor. You know, your wife can be your executor. Even there is no law that forbids the children from being executor of a will. The only condition is that you must make sure that the beneficiaries are not the witness to the validity of the will. You must not make that mistake, because once the beneficiary is made directly the witness to the will will be set aside. So I think at that point, that principle will come forward, that a beneficiary in a will cannot also be a witness. So make sure that you have the independent mind, you have a sound mind, the person is not sick, the person is not mentally affected, it's not it does not have any health challenges. Then if once the person is sound, then the first step has been complied with. Then the second one is that who are the beneficiaries? If you have 3 children, then identify them. Then how many properties do you have? Identify those property, whether they are 6, and you want 2 to go to each of the child, And not only that, make sure that there are people that will witness whatever you write. And beyond that, you make sure that you appoint executors, and not only that, if the children are still young, appoint a guardian that will take care of the children till they attain the majority age, which, as I said, is 18 years in some states and 21 years in some countries. So, having appointed a guardian, if you know that, well, the children might not attain the majority age, you can also appoint a trustee. A trustee is a person appointed in law to hold the property in trust till the time the children will attain that majority age. So the law allows the testator to do all of these as preliminary steps and having a valid will under the law.
Thank you so much. It's been wonderful having you on the show. Thank you very, very much. And thank you too for being part of the show. I hope you've learned a lot about writing a will. I'll just leave you with this. Writing a will is not gender based, it's not about your finances. As long as you have something that you've worked for and you would want to protect and leave, pass on to those you love, so you can actually write a will. It's not about you dying anytime soon. It's just about you securing the future for yourself and those you love. Until next time, I remain Olujoke Musaku. Bye.